Hello everyone, welcome back to another episode of the Darrell Brooks saga. I'm back from vacation, so we're gonna continue with the videos. We're gonna finish day 13 today, which is gonna be just continuing with the rants and tantrums of Darrell Brooks. Today, I think he was expelled again from the courtroom, so let's see how it does. First of all, thank you guys. We started the year, we're already at 1300 subscribers. That's awesome. I want to thank you all for the continued support, and there's just no words for me to thank you guys. I'm always gonna be humbled by you guys and by what you do to support the channel. So thank you. All right, let's get into the video.
Appears he has headphones on. Speaking of headphones, I do need to make a correction to the record from this morning. I had made a statement that, given his demeanor, the headphones had been taken off the table by the bailiffs. I was incorrect. Mr. Brooks handed the headphones to the bailiff, saying he didn't want to break them. All right, so we are discussing the verdict forms. Mr. Brooks has been muted. I am going to unmute him right now. And I should state again for the record, all of the verdict forms, or at least the drafts, were provided to him prior to the lunch break. So he would have had an opportunity to review them should he have chosen to do that. Do you have any position on the verdict form, sir?
I wasn't provided with anything, and if I was, I accepted and returned it for value. And since I'm now in another courtroom, are we going to address subject matter jurisdiction?
What does it matter if you're in this another courtroom? It's the same thing. It's the same trial, and she already. That's my thing. She always already addressed that.
You have yet to prove it for the record.
Mr. Brooks, you were provided with the verdict forms. What you did with them, I don't know.
Again, I haven't been provided with anything.
They were provided to you prior to lunch, the lunch
I
break.
haven't been provided with anything.
So he's not saying that they didn't give him the papers. He's saying that because he has accepted for value and returned for value, that means that he didn't get anything.
Teresa, you had the large packet of verdict forms. How were they given to Mr. Brooks prior to the lunch break?
By hand to the bailiff and the bailiff to him.
To be, and the bailiffs are confirming that the verdict forms were provided to him on his table. But given,
Am I muted?
no, you're not. You haven't been.
So I got a question about the enhancer for use of a dangerous weapon. How's that being charged? Is that under 939.632?
It is in the charging document, sir.
How's that being charged? From my understanding, that the statute reads the increased penalty provided in this section does not apply if possessing, using, or threatening to use a dangerous weapon is an essential element of the crime charged. Without the vehicle, there is no crime. So that would apply. So how am I charged with?
State want to is your argument only as it relates to counts 1 through 6 or others?
Whichever count has the enhancement penalty for use of a dangerous weapon.
Well, that would be all of the intentional homicide charges and all of the first degree of recklessly endangering safety charges, so counts 1 through 67.
So 1 through 67.
Correct.
So what he's now he's actually arguing. Now he's actually participating on the thing. He didn't do it all day, but he's doing it now, and he's saying, "Why am I getting an enhancer on my charges?" Which I don't get why. If they take it out, which was one of the offers of the pretrial, the offer that the prosecution gave him. What difference it's gonna make? You're still gonna be there for 6 lifetimes. It doesn't matter if the enhancer is applied.
Have the state respond to that.
Yeah. How is How is the alleged defendant being charged?
So are you asking how are you making a specific request as it relates to the special verdict question?
I would say both. Seeing as how I don't understand how,
Now he doesn't understand.
that's why there's the question. Reading the statute,
And
How
which
is
part of
that
this, I'm sorry, which part of the statute are you referring to again?
I believe it's 939.632.
And your specific argument is what again?
How is that enhancement, how is the alleged defendant charged with that enhancement when reading the statute it says it, well, I just read it, so.
All right. An argument, an actual
I believe you're
argument.
referring to sub 2, which states the increased penalty provided in this section does not apply if possessing, using, or threatening to use a dangerous weapon is an essential element of the crime charge.
Charge, right, that's what I just read, Your Honor.
Well, what's the state's response?
Using, possessing, or threatening to use a dangerous weapon is not an essential element of either first-degree intentional homicide or first-degree recklessly endangering safety. If it were, it would be one of the elements in the standard jury instructions, and the defendant can see it is not. This is different from a situation like armed robbery, which does require the use or threatened use of a dangerous weapon. So the penalty enhancer is correctly charged for those two types of crimes.
Any final argument on that, sir?
Yes, that's not what the statute is clearly saying. It's clearly stated it does not apply if possessing, using, or threatening to use a dangerous weapon is an essential element of the crime charge. If there's no vehicle involved, where is the crime? It has to be an essential part of it to even be a crime.
No, I think he doesn't get it. The way that I get it, that I understand it, is that if in the name of the charge, like Zach said, the armed robbery, you need to be armed in order to be charged with armed robbery. He wasn't charged with running over people. He was charged of a first degree thing on a life. So that's what Zach said, and he doesn't get it. He says that because he used a vehicle, that means that he doesn't need to get that enhancer, but he is correctly charged.
The alleged defendant is charged with using a vehicle to commit these crimes.
Yeah.
If there's no vehicle, where's the crime? So it has to be an essential element of the crime. Otherwise, there's no crime. I think it's the essential element. If you read in the statute, it's the essential element.
Nah.
You can't just walk up to someone and quote unquote run them over.
Yeah, but you weren't charged for running over people. That's not what you did. That's not what you're charged with. That's what you did.
There has to be something used in order for this alleged crime to transpire, and that would essentially mean the quote unquote dangerous weapon. So without the quote unquote dangerous weapon, where's the crime? So how can it be charged when it is the essential element of the crime charge?
Well, sir, I've listened to your argument. I've read the statute. I've looked at the elements for intentional homicide and first degree recklessly endangering safety. Neither one of those crimes have as an element in it use of a vehicle. There are certainly many different ways that both of those statutes can be violated. While it's true that in this particular case the use of the vehicle is the mechanism or instrumentality that's being alleged to have been used, but it's not the same as being an essential element of the crime. I think the armed robbery crime is a good example of when you could not face an enhancer for use of a dangerous weapon because you can't have the crime of armed robbery without the threat or use of a dangerous weapon. And
Yes.
so
That's the same argument in this, Your Honor. You
No.
can't have this alleged crime without the use of the vehicle.
She just spelled it out for him. She just said that because there's many ways to violate that statute. That's what it applies here.
It's the same. It's the same thing.
it's not an essential element of either first degree intentional homicide or first degree recklessly endangering safety. So I'll deny the request to strike the enhancer for those reasons and find that it is properly before the jury for their determination.
There you go.
I respectfully object to that, Your Honor.
Understood. Do you have any other challenges to the verdicts you'd like to raise at this time?
No, that's it.
Would that be? Will my objection to that be noted for the record?
It is.
May I request a legal reconsideration of your ruling, Your Honor?
Denied.
May I request
I love that she's just like, denied. I'm done.
a written finding of fact for your ruling, Your Honor?
No.
Denied. Just for the record, it's my understanding that the verdict forms were put in the garbage by Mr. Brooks and they remain in there. That was provided to me by the bailiffs.
May
That
I
information.
respectfully request a written judicial finding of facts
Yep.
and conclusion of law for this issue, Your Honor?
he forgot to bring up his little checklist, so now he has it in front of him. So now he remembers. He has to go back and ask again.
You may request it. The request is denied.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
This is not the proper court to grant such relief.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction?
Your request is denied.
Based on what law or fact?
Your request is not based in law or fact, sir.
I just read a statute that it came from. My argument was based on a statute, a Wisconsin statute.
Your request is noted. Your objection to the court's finding and determination is noted. I decline to issue any type of written decision or stay pending appeal, noting there is no appeal that has been filed.
May I let the record show that this court will not allow the accused to adequately defend themselves in this matter?
The court's already made its findings regarding the forfeiture of right to testify and the forfeiture of the right to present additional evidence and testimony.
Which was not-
I'm not going to
which was
revisit
not
the
consented-
same.
Which was not consented to. I never stated that I did or did not want to
Understand.
testify.
I understand.
He doesn't get that by saying that I just stay mute. That gives her the opportunity to do whatever she wants, so she can move on with the trial, even if you just stay there, because you cannot stall the proceedings.
So how can that decision be made on my behalf when I didn't say either way? What I stated was I didn't understand the questions being answered.
Sir, do you have any other questions or issues regarding the verdict forms?
Your Honor, are you making a judicial determination that you don't have to answer any questions?
I'm not answering those questions, sir, other than how I've already answered them.
Is that a judicial determination?
Sir, every decision I make is a determination by this court.
Is it a judicial determination?
Yes, she is the judicial. Is she the judicial power? She's part of it. So, yeah, every determination is final, and that's just what it is. You need to deal with it.
Sir, I will ask you once more. Do you have any other issues
And I will
to
tell you
raise?
once more, I
with-
don't understand the questions that you are asking.
Sir, do
So
you
I
have
would-
any other issues to raise with respect to the verdict forms?
I do not understand the questions that you are
He
asking.
has now
I don't
twice
understand.
not answered the question. I'll ask one last time and specifically advise him that his failure to answer the question will be taken by this court as a no. Sir, do you have any
Under what law or
additional?
fact? Under what law of fact can you say no? When I'm
Sir, do
telling
you
I
have
don't
any
understand?
additional issues to raise with respect to the verdict forms?
I do not understand the questions that you are asking.
All right, he
I
has
don't
chosen
understand.
not to answer other than by saying he does not understand the questions. He did not specifically answer with a yes or no. Therefore, this court takes that as he does not have any additional issues
That
to
is-
raise with
that is
respect
incorrect.
to the
That is
verdict
incorrect.
forms.
All
That
right.
is incorrect.
If it's incorrect, then what do you want to say? That's all we want. She wants you to say, yes, I have an objection to this, or I have an objection to that. But you don't say that.
I say that I don't understand. You can't force me to understand something, Your Honor. You
All right,
can't.
did the state have any
It is-
other?
It is my.
I want to mute him momentarily.
Good.
Mr.
My
Brooks, I'm muting you
constitutional
because
right.
I'm moving on to another topic. I understand you disagree with the court's rulings, but you need to respect the rulings with proper etiquette in this courtroom, which you are demonstrating once again you're not willing to follow, so I exercised my ability to press mute. Does the state have any other requests as it relates to the jury instructions? I want to kind of full circle back to that because I do need to approve of them.
Yes, we do not.
All right, Mr. Brooks, I'll ask you the same question. I will unmute. Do you have any additional requests as it relates to the jury instructions?
Yep, I have questions related to all of them because I don't understand any of this.
My question was not, do you have questions, but do
And
you have
my
any
answer
requests?
was, I don't understand. And I've made several requests.
The requests are not related to the jury instructions, which is the phase of this hearing that
I
this
did-
court is attempting
I
to
did
conduct
answer-
with you and give
I
you the
did answer the
opportunity to
question.
fully participate. Mr. Brooks
You
is
did
choosing
not.
not to answer my questions.
You did not.
I'm going to mute him momentarily, sir. I will ask you one more time if you have any requests as it relates to the jury instructions. I then will ask you if you approve of the jury instructions. If you do not answer those questions as it relates to the question, do you have any requests as it relates to jury instructions? I will interpret that as a no. And if you do not specifically answer the question about the jury instructions, I will interpret that as your approval. So first question to you is, do you have any, and you're unmuted, do you have any requests at this point as it relates to the jury instructions?
And I just said before, I said I do. I said I don't understand the questions. Of course I have questions if I don't understand.
Ignorance of the law, or ignorance of the proceedings, or everything that comes around with that is non-valid. You cannot just say I don't get it, because you're supposed to get it if you wanted to represent yourself.
So do you have any
That's common
requests
sense.
for any additional instructions that are
Yeah.
not included, or to remove any that are included?
Yeah, remove them all until I understand, or add the jury instructions that I have myself.
What jury instructions do you have, sir?
So now you don't know I had jury instructions, and I told you this weeks ago.
What filing are you referring to, sir? If I've overlooked that, I will certainly reconsider, but I'm not
You
aware of a
overlook
specific jury instruction.
It seems like you overlook a lot, Your Honor.
Can you,
He's not talking about jury instructions. He's just saying that he filed a bunch of stuff, and that's what he wants on the record. But that does not have anything to do with the jury instructions.
point me to a specific filing?
So you have all my filings on file?
Yeah.
Are you saying that you have my filings and they haven't been admitted into evidence?
Yes.
Oh, my computer's not working.
Oh, no.
Yes, that's exactly what she's saying. That all your stuff is on file. It has to be there because you put it there. But that doesn't mean that it's gonna become evidence at any point because it's hearsay and nonsense. That's it.
Computer's not working.
I'll help you, Judge. I can help you.
Sir, please direct me to the specific filing that you're referring to that has a request related to jury instructions.
You just said you was referring to the filings.
Which
right?
one?
Did you just say that?
That's not what I said.
Didn't you just say what filings are referring to jury instructions. Did you or did you not just say that?
I said, do you have a specific filing you can refer the court to that relates to jury instructions?
So is your computer working or is it not working?
It's
I said
being a
this-
little
I said this weeks
temperamental,
ago.
but I just can't use my search function, so if you can direct me to a filing, that would be great.
He has
It would
nothing.
also be great for those filings to be admitted into evidence.
Sir, simply filing something with the court does not make it evidence during the evidentiary phase of a trial. There are rules of procedure and rules of evidence that govern that.
And you told me to make all my filings in writing.
Sir, I said if you had a motion, it needed to be put in
All those
writing.
were motions. All those were motions.
Sir, what filing are you referring the court to?
Look through all my motions.
Sir, it's not my job to advocate on your behalf. If you have
I
something
didn't
in
ask you to advocate
particular,
on my behalf.
Sir-
I asked you to do your job.
sir, if you have something, a specific request, now is the time to make it.
Well, how about this? I don't accept none of those jury instructions. I don't accept any of them. Any of them.
Why?
And again, I'll tell you, I don't understand. Why do I have to keep saying this when it's clear that I don't understand?
Your Honor, I can inform the court that jury instructions were due, I believe, on August 30th. The state submitted their proposed jury instructions as well as the substantive instructions, and the defense indicated that they agreed with our filing. So I don't believe that there's ever been a request for any different jury instructions than what have been filed with the court.
So what jury instructions are you referring to, or what document is being referred to on the alleged defendant's behalf? Because as we all know, I didn't obtain the discovery in full until the end of September. So there was documents that I didn't even know that existed.
Mr. Brooks, one final time, do you have any specific requests as it relates to the jury instructions other than your request that they all be struck?
And I'm telling you, Your Honor, I don't understand the question. I can't.
All right, then I will take his response that he does not understand, that he does not have any additional requests.
I didn't say
And
that.
they will be
I said I don't
approved.
understand.
They will be
can't-
approved and are,
No.
I'm going to have to mute
No.
him. They are approved. I am also approving of the verdict forms. The content and substance are there, and I've already addressed on the record any requests by the parties this afternoon.
The final copy that we've been working off of is appropriate.
All right, very good.
Any comment about that, Mr. Brooks, or any statement?
I don't consider being called that name, and I've just told you I don't understand these jury questions. I'm not going to know how they allowed to pass just because you feel that they should. When I'm telling you I don't understand them.
I would note
None
that
of those, not one of those jury instructions came from me. Not one. How's that fair?
Because
Mr. Brooks.
because you didn't present it. They give you 100 opportunities to put something in there, and you were like, nah.
This court gave you the draft
No, you didn't
of
give
the
me
jury
anything.
instructions.
You didn't
I
give
need
me
to
anything.
mute you because, once again, he's debating about things that I think are very clear on the record. This court provided both the state and Mr. Brooks with a written printout, 107 pages long, of the jury instructions it was considering in this case. I had a brief opportunity to look through the record of the inmate communication forms that have been sent during this trial that are on file. I haven't seen anything that references jury instructions. I'm well aware that he has other filings, but I could not find anything related to jury instructions and
Nothing.
any
There's
specific
nothing.
requests that he is making or made during this case. So for the record, I am approving of the verdicts, I am approving of the jury instructions, and once again, before we break for the day, I will make sure to provide the parties with written printouts of both of the documents as they now stand.
We just wanted to address timing generally for closing arguments, verdict returned by the jury, and then the court's intentions as to the rest of the week, should there be guilty verdicts returned.
Sure. Before I address all of those, are there any of those final type of issues, sir, that you would want the court to address? You have been unmuted, so you can answer that.
He has the headphones on. He's done. He's done. He doesn't care anymore.
Mr. Brooks, do you have any of those final type of questions or issues that you want the court to address?
She's referring to me.
You are unmuted. I am.
I just told you since nothing I say even matters at this point, I'm just gonna tell the jury what they need to know. I'm just gonna tell them the truth.
Mr. Brooks, you are aware that your closing arguments have to be based on law and fact, correct?
They're gonna be based on whatever I'll base them on.
Big man.
Well, I trust the state will object when appropriate,
Well,
if
it's gonna be
appropriate.
a whole lot of objection then because I'm gonna tell the truth. You haven't allowed. You just been making all the decisions for me, even though you know I told you repeatedly that I don't understand, and you still make decisions based on my behalf without my consent, without me. I'm telling you I don't understand, and you still make a decision determining my life.
Yeah, that's her job.
Are you telling me, sir, that you will refuse to follow the simple rules of decorum, courtesy, civility, the rules of evidence, and
don't try to come
the
with
rules
your
of
slick
procedure?
words. Don't try to come with your slick words and don't put words in my mouth.
Sir, I am not being slick. I'm trying to
You've
preserve the integrity.
you've been slick. You've
All right.
been slick.
All right. I'm going to mute you, sir, since
Thank
what
you.
you are saying is not productive. It is not courteous. It is disrespectful.
I don't care.
I
what
need
you
to.
think.
I need to go
I don't
over
care
these.
what you think.
All right. Do you have any estimation on the length of your closing? I'm contemplating maybe putting a time restriction. Do you think it would be reasonable to give the parties each an hour total? That would reserve whatever's left from your initial for your any rebuttal.
Yes.
All right, Mr. Brooks, do you have any position on that? I am unmuting you. I would note he takes the headphones on and off throughout. He doesn't have them on. He's looking.
You see how he sprung when she started talking about what he does? He was like, "What?"
At a book.
There you go.
I wish you would stop saying, look, I'm looking at the Bible. Thank you. It's not just a book. It's the book.
Can't disagree with you there, sir.
Yeah. How many people actually live by it, though? Anyway.
You don't. You hit people. You run over people. You don't live by the Bible, my guy. I'm sorry.
Sir, I'm contemplating putting an hour time limit on closing arguments.
I ain't
You
doing
lie.
no closing argument tomorrow.
The closing arguments will most likely be tomorrow.
I'm
Given,
not doing it tomorrow.
then you'll forfeit your right to give one, sir, because as we have,
You can't force me. You can't force me not. What type of court is this where you can say you're gonna force somebody not to be able to give a closing argument? How's that lawful
sir,
law?
if you choose
How
not
is
to
that
give
lawful law?
one,
How's that lawful law?
sir, if you choose not to
Damn,
give
good,
one,
right.
you're not letting me finish, and you're mocking me
Okay.
right now, which is incredibly disrespectful once again.
Okay,
You didn't
take
even
that
let me
how you
get my
want to.
sentence
You
out.
always want to make a incorrect record. Go ahead, make your incorrect record. Go ahead.
I'll mute him once again because clearly he just wants to be disruptive. But you should be prepared to go tomorrow afternoon. Then the state, if they have any rebuttal, will get up within that time limit. I will myself and I'll have my clerk make sure we accurately time that. We can get this done tomorrow.
Yeah.
And so that's my expectation. So, Mr. Brooks, I'll unmute you, but that is the expectation of the court, that closing arguments will be done tomorrow.
You can't rush me to judgment, or you can't practice law from the bench and tell me when I can do something and when I can't.
She
Mr.
can.
Brooks, I actually can, under all of the rules of procedure. It is my
Okay.
job to make sure there's effective
Okay.
and efficient administration of this trial.
So,
You
so
are,
then I should be allowed to, then if that's the case, then I should be allowed to tell the jury what they need to know, which is the truth. That they have the power. They have the power to nullify laws if they don't agree
you
with
are
it.
absolutely not allowed to tell the jury that. There's a jury instruction that I will have ready to go if you even attempt to raise the issue of jury nullification, sir. You have absolutely no right to raise that. That is
Oh,
clear under the law.
I can raise what I want to raise.
No, you don't.
And you can't, so you added these jury instructions at the last minute, then you should have never approved them from the get-go because I never approved them. I told you I didn't understand them at all whatsoever, and you still passed it.
Sir, if you understand jury nullification, you understand jury instructions. It's clear to me
Man, I
you've
don't
done your
care what
homework.
you're talking about. I don't care what you're talking about. I'm going to let them know that they can nullify any law they don't agree with, which is my right.
It is not your
Now,
right
say
to do
it's
that.
not. Say that it's not.
It is not.
It is
Tell me
not
where
your
it's at.
right to raise
Show
jury
me.
nullification.
Show me lawful law then. Show me.
All right, I'm going to mute him once again. He's starting to raise his voice. He's starting to hit his hands on the table. It's very clear to this court that it's going to be a challenge tomorrow during his closing arguments. He does not have an unfettered right to say whatever he wants or how he wants. If he is going to be adamant about defying the court's rules, which I will tell him in part what they are today, and I will work on that as we break and have a very clear advisement for him tomorrow morning. He may run the risk of being put in the other courtroom because he'll forfeit by his conduct his right to be present here, and I will be able then to exercise the mute function. I have to balance, frankly, the fact that he's in custody, that it takes time for this jury to be excused. They have to walk an entire hallway behind me. I frankly don't want him to look worse than what he's looked, frankly, in front of this court when they haven't been in this courtroom. I need to preserve how he looks to this jury. And I will need a very clear pledge by him that he will follow the rulings that I make as it relates to the closing arguments. He cannot raise jury nullification. He cannot raise facts that are not part of the record. He cannot raise subject matter jurisdiction. If he can't pledge to follow these very simple rules of courtesy and decorum that are consistent with the rules of procedure and the rules of evidence, then he will be in that other courtroom for his closing argument, so that I can exercise mute, frankly, to protect how he looks to that jury. Because that is the balancing that I am tasked with tomorrow, is to ensure that this jury makes a determination based upon the evidence and the law. Those are the very clear rules that you will need to follow. And like any other time in this trial, if you don't do that, you will forfeit your right to argue your case to the jury, or forfeit your right to be present in this courtroom and appear from the other courtroom. And you are squarely put on notice of that here today,
I love that he's talking well muted. I just love that.
sir. Mr. Brooks, any further topics by you?
Am I muted?
No, you're unmuted.
So, again, I don't understand nothing you just said, but I don't. How can you deprive me of my constitutional rights? How can you trample on my constitutional rights?
He just explained that.
How?
Sir, you can forfeit a number of constitutional rights by misconduct on your part.
Not if I reserve my rights. You can't. let me reserve my rights and then take them from me.
Sir, I direct your attention to Chambers versus Mississippi,
I'm not
Rock
gonna
versus
hear none of that.
Arkansas, State versus Anthony.
He always is like, show me lawful law, and when she actually does that, he's like, nah, I don't want to hear any of that.
Illinois
Did they
versus
reserve their
Allen.
rights? Did they reserve their rights?
The
Did
Beneby
any of those
decision. There's a host
Did
of
they-
case
did they-
law, sir.
Did they reserve their rights?
All right, sir, you are simply mistaken on that. So I'm muting him once again. He's not giving me any other issues to address. We are in recess.
Oh, I'm sorry, I have a few
Go
other.
ahead.
I'm
You
sorry.
do. I'm
Yeah.
sorry. Go ahead.
I just wanted the record to reflect that at about 2:04 p.m., your clerk had provided the final version of jury instructions to both the state and to the defense. I watched on video as Deputy Wittig left this courtroom, went over to the other courtroom, handed the final jury instructions to Mr. Brooks, and he immediately turned and dropped them to his left off the side of the table. I can't tell from the video if that's where the trash can is located or not, but I did see that immediate response after he was handed the final jury instructions.
Okay.
Yeah,
just
it's some
the jury
video.
instructions. But thank you, because I didn't see that given some of the things I was looking at up here, so I appreciate that. I see your arms waving. I'll get you in a second. That he's provided with that as well, and you as well.
Hello.
Mr. Brooks, I'll get you. I'm unmuting you. Go ahead. Go ahead. You're unmuted.
And since we're all making records to make me look bad, I think we should state for the record that one of the rights I have is to demand that the court places in evidence any unrevealed contract, statute, laws, rules, or information being used against me under the Sixth Amendment. So how come that hasn't been placed in the evidence?
What law are you referring to, sir?
I'm referring to my rights under the Sixth Amendment.
And what
My
case law
constitutional
says you
right
have a
under the-
right to do exactly what you just said you have a right to do?
The Constitution, Amendment 6.
That's not how it
Sir,
works.
that is very general, your statement. It's vague. There's nothing
So we gonna go
specific
what?
you have
What
referenced.
You want paragraph 2 or something like that? Is that what you want?
No, that's not what I'm saying, sir. You're making
So,
general arguments
also-
that aren't based in fact
Yeah.
and are overgeneralizations of what the law requires.
There he goes, and he drops it again.
I accept for value in return for value any documents in this matter. Since, it might be another record of what I'm doing, since it's always a record of what I'm doing.
Yeah.
And I also have the right to ask, is this common law or admiralty law? Because judging by the gold people on top of the flag, it's some explaining that needs to be done. And that is a military symbol. So is this a common law court or admiralty law court?
Mr. Brooks, I'm frankly not going to address these nonsense legal theories of yours. I'm
Thank you.
muting you. They have been debunked. They are typical sovereign tactics that have no place in our judicial system. We are in recess. I'll see everyone tomorrow morning at 8:30. I'll just direct the bailiffs to wait until we have the verdict forms to give. And if it takes us longer than 30 minutes, we'll make sure they're delivered to him in his jail today. Thank you, everyone.
Thank you.
All right, so that's it for day 13. I'm gonna see you guys tomorrow for day 14 and the closing arguments. Thank you guys for watching. I'll see you guys on the next video. Have a great day. Bye-bye.